My first guest is criminal barrister Diana Constantinide, and I'm delighted to have her on the show to discuss her thoughts on anonymity. Diana, good evening.
Hello, good evening, Lawrence.
Could you talk me through the legal repercussions of anonymity and why it is in place in the legal process more broadly?
Indeed, you said something very correct. You said that justice needs to be seen to be done. So the overarching principle here is that the defendant must receive a fair trial. And that is well established in our domestic law, but it's also enshrined in Article 6 of the European Convention of Human Rights. Today at your show, you're going to hear from both sides. So we have the victim side and we have also the defendant who's been falsely accused. And the law has to make sure that it encompasses both of those situations and scenarios. So we have the victim perspective and the defendant's perspective. You very correctly pointed out that the victims, they do suffer emotional and physical abuse. And it is a difficult stage to actually accept that and go and complain and make a report to the police. Now, from the defendant's perspective, if they have been falsely accused, of course, it does have overwhelming implications into their life, especially when the media is there on the spotlight. So the principle the principle of anonymity is to protect the victims and to make sure that they do come forward and report those cases. Now, what can we do about it? We have the Sexual Offences Amendment Act 1976 that provides a lifelong anonymity to victims. That was the law that allowed for the defendants to have anonymity, but it has been repealed in the Criminal Justice Act 1988. So the question is, do the defendants still have the right to anonymity? And it is simply no. They do not have that right anymore, but it was back then in the case. So it may well be the case for us to look what happened back in 1976, what the Parliament thought about it, and what statistic analysis they had to allow that to happen.